My name is Zack Oliva, and I'm one of the owners of Oliva Gibbs.
My name is Brad Gibbs, also one of the owners of Oliva Gibbs. Welcome to Good Energy Talks. Our special guest today is Professor Chris Kulander from South Texas College of Law.
Hello, yes, I am Professor Kulander, South Texas, and also of counsel here at Oliva Gibbs. So I'm happy to be here.
So in the Good Talks video series, what we do is bring in experts such as Professor Kulander to talk about important developments in the law, as we are a law firm that represents oil and gas companies. So we update our clients and the market on our perspectives on some various cases that are making their way through the court system, which could directly impact our clients and their operations. So I think, what's the first case that you want to talk about today, Brad?
So there's been some interesting cases that have been raising some eyebrows across the industry, and particularly here in Texas, that deal with non-operated interests under joint operating agreements. And the first of these was the Cimarex case that involved Anadarko, and it gave rise to what's been sometimes referred to as an Anadarko washout, because it seems that Anadarko is involved in quite a few of these. So in the Cimarex case, we saw an instance where Anadarko basically came in and said, if you are a non-operated lessee and the language sort of reads in a specific way under your lease, that your lease is not going to be extended into its primary term by an operator's activities. So even though you have production on the lease, you could, in theory, lose your lease. This was somewhat surprising across the industry. I think a lot of people didn't expect this outcome. And shortly thereafter, and working its way through the court systems now, is the Cromwell case, which it was Cromwell versus Onshore. Onshore is also an Anadarko entity. And one of the reasons I thought this would be a good case to touch on today is because Professor Kulander actually filed an amicus brief with the Texas Supreme Court in this case. And Chris, if you wouldn't mind telling us a little bit about the brief you wrote.
Well, it started last year when the Cimarex case was the first one you mentioned, Brad, was winding down. And I discovered it when I was doing case law update late enough in the cycle that I couldn't have any bearing on it. I tried to jump in, couldn't at that point, and then it was settled in a way that I thought wasn't very good. And then, quite independently, the firm that was representing David Cromwell did not contact me. I found this case come out of the Court of Appeals, and I said, good heavens, it's that fact pattern again, and by George, it's the same company. So at this point, I contacted the firm. I didn't want to step on any toes that's representing Cromwell, and I said, do you mind if I read an amicus brief? And once they stopped dancing around the table, they decided, well, yes, please do that. In this brief, I say that the fact that that lease did not require production by the non-operating lessee meant that that lessee could rely on the production of the other party to take them into the secondary term of the lease. I think it really comes down to that crux, and that's what drove my amicus brief. I've written a paper on Cimarex. It just came out in the UNT Law Review last year, and so basically my brief was kind of a roadmap back to this case with UNT's new law review.
So why do you think that the first case didn't get settled correctly?
In the first case, Cimarex, again, that lease said this lease will be held for X number of years and so long thereafter as production is maintained, period. It didn't say maintained by the lessee, it just said is maintained.
So real quick for the folks watching, why is that significant?
It's significant because it doesn't have to be Cimarex in that case that achieves production by itself. Mm-hmm. It can be any of the lessees because the lease expressly does not require production by that particular lessee. Mm-hmm. And that's a negotiated point in many leases. You'll see a lot of leases that say production has to be maintained, for the lease will last so many years and so long thereafter as production is maintained by the lessee. Mm-hmm. And in that instance, yes, Cimarex and Cromwell would have to produce themselves. But when you don't have that language, and it would seem that they wouldn't. And the court in Cimarex just ignored that lack of language, which I found perplexing given the fact that they really take a microscope to the words in these cases, as Brad knows.
Yeah, and so in that case, in both of those cases, Anadarko made the argument that basically the only way to perpetuate a lease in Texas past its primary term, if you were a non-op lessee, is to execute an operating agreement. And the El Paso Court of Appeals, in both of those cases, I believe those were both out of El Paso, weren't they?
Perhaps, or Eastland, I think.
Okay.
Maybe one of them was, but
Well, either way, the court kind of doubled down in those cases and said that, unless you have this operating agreement, there's no way you're going to extend your lease. They kind of dismissed out of hand any argument that might lead to a constructive operating agreement or any kind of constructive mining partnership or anything like that. And in your opinion, do you think that's an overly strict reading then of the habendum clause in the lease?
absolutely. Absolutely. And I don't think it does justice to the express terms, or I would say the express omission of the words by the lessee. And when we look at the Cromwell case, we see it going a little bit farther. Now they were asking the Cromwell, the non-operating lessee, do you want to participate in this project, or are you going to go non-consent? And they were doing things that you find in a joint operating agreement, and yet they refused to sign a joint operating agreement. I would argue this is a mining partnership, and production by one should count as production by all, unless the lease expressly provides for it, and it did not.
It seems like a very coercive tactic and one that could be ripe for abuse if the party sort of holding the right to circulate the operating agreement withholds it and doesn't give the non-operated party the opportunity to enter into a negotiated JOA. So it'll be interesting to see what the Supreme Court ultimately decides to do with these cases.
Yeah, and it's really, I think, indicative of what's going on when you say a little coercive, in the sense that who was the top lessee that was waiting for the bottom leases, for Cromwell, for Cimarex to go away? It was Anadarko. When you pulled that mask off, oh good heavens, look at the party that was there, that was stiff-arming, saying no JOA, and then they find themselves to be the lessee. That's interesting.
Speaking of the Cimarex and Cromwell cases, it's an interesting time to be a non-op JOA partner in Texas, especially in light of the recent PBEX versus Dorchester case. And that case involved another kind of washout, but in this case it was an adverse possession case where one non-operated interest adverse possessed another non-operated interest. Kind of a case of first impression, not only in Texas, but anywhere, I think, as far as anyone can tell. So have you been following this case at all?
I have, and I tend to have opinions. Have opinions will travel. I tend to think that Dorchester has a pretty strong argument here. I think that when you look at some of the common law tenets of adverse possession, paying the JIBs for the other party, taking part in decisions on whether or not operations are going to go forward out there, and whether or not they're going to participate, would really seem to me to meet these open and notorious possession activities. So my initial impression as this moves its way through is that Dorchester's got a pretty strong argument.
One thing I thought was interesting in that case as well was that they said that going non-consent under the JOA did not interrupt adverse possession, and that it had been continuous, through sort of the life of this interest. So certainly another interesting case, also pending before the Supreme Court, and we'll watch that one. So an exciting time if you're a non-op owner, probably a little bit of a scary time in Texas.
So what are the dangers to non-op owners?
Potentially that they would just lose their interest completely, and that they would have very little power to do anything about it.
So what could non-op owners do moving forward in light of these cases?
Well, of course, the gold standard is going to be sign an operating agreement, make sure that you have a clean chain of title to your interest, which is kind of what happened in the PBEX Dorchester case, and to just make sure you're really paying attention.
Yes, and I think one of the scary things too about these is if you're a small interest and you're required to produce, it might not be economically sensible for you to produce with, say, as in the Cimarex case, a 1/6 of the interest.
So it might add another layer of analysis that you need to do in your operations.
Yes, and bring in accounting to think, well, if we have to produce ourselves, is it going to make sense to do that?
So this could lead to a lot of, both economic waste and depletion of the reservoir if you're saying that every working interest owner has to drill their own well or be Anadarko washed out, on their interest. And so it's going to be interesting to see where this goes. Obviously, that would lead to a lot of inefficiency, cluttering the field again, going back to a spindle top type scenario where everybody's rushing in to drill their own well to maintain their lease. I have a feeling that even if you just look at it equitably, the Texas Supreme Court is not going to necessarily like that outcome, but they've surprised us before.
So would they consider that outcome in their decision?
I believe they would. It's certainly been well pled in the briefs up until now. So
the Texas Supreme Court recently asked for a briefing from both sides in the Cromwell case, and both parties have responded. And so we'll see where that goes in the future. I wouldn't be surprised at all if the Texas Supreme Court takes up Cromwell. And if it goes the other way, kind of cold comfort for Cimarex, because that case has already been decided.
So thank you everyone for watching this episode of Good Energy Talks. I'm Zack Oliva. This is Brad Gibbs. Brad, if you can give us a rundown of the cases that we discussed today.
Sure. Today we talked about the Cimarex case, the Cromwell case, and the PBEX versus Dorchester case. These are all cases relating to operating agreements and non-operated interests in Texas, and all great cases to be aware of if you own non-op interests.
Brad and our team frequently write and present on, the most recent and pressing issues in the energy industry. You can find those on our website, on our LinkedIn, YouTube, Twitter, I think. Also, if you're a non-op company, this is an especially important episode for you to watch because Professor Kulander gave us some great insight on how these cases directly affect your operations moving forward, and for things to watch out as these cases come down from the higher courts. Professor Kulander, thank you very much for being with us today.
Hey, you're welcome. Appreciate it.
Appreciate your time.
Thank you.
Thank you.